lords, then my lords, submission would be, my lords.
Submission is what?
My lord, that it was a limited inquiry.
Take down first. We'll decide.
The modification for extension of time, Your Lordship.
Huh?
We have filed a modification.
How can you seek for modification when it has lapsed? Where is the question of modification?
List of,
Your Lordship, the process is on there. Your Lordship, with respect to 3.5 lakhs, the process is going on for verification of the certificates, Your Lordship. Some further time will be given, Your Lordship, will come.
No question of granting time. It has already lapsed. You are committing every day contempt after lapse of 8 months.
Your Lordship, we have filed an application before the lapse of the time, Your Lordship.
Let us examine.
Lord, I am giving the list of dates and events, my lord. एक मिनट लीजिए. Discuss, sir. List of dates. Now, my lord, kindly have a look to annexure 21 onwards. My lord, this has a checkered history. Earlier,
What was the post held by the petitioner?
assistant godown manager.
Assistant
Godown manager.
Godown manager.
जी. Bihar State Food and Civil Supply Corporation. He was. Lords, kindly look to annexure 21 onwards, because this is the second round of litigation. An earlier round of litigation, my lord, that would be very relevant. From page, my lords, order of dismissal was earlier challenged in writ petition, my lords, void annexure 21. That was, my lord, dismissed on the ground of delay and laches. That is at page, my lords, 111. Against that, my lord, we moved in LPA number 1078 of 2020, my lords.
1078
of 2000.
No, what is that? 778 of 2000.
List of date, my lords.
77 LPA 778 of 2000 was dismissed
My lord,
on 8/8/2000.
yes, my lords.
But you are not saying that.
No, that.
No, you said 1078.
That is 1078.
Correct, sir. Why are you skipping 778?
No, my lord, that has been wrongly typed. 1078. That is 1078. It was restored pursuant to order of the Supreme Court. The next line is correct, my lord.
This is not 778.
No, my lord, 1078. I am sorry, my lords. My lord, it was also dismissed LPA on the ground of laches because delayed action, if permitted, would result in floodgate. Thereafter, we moved the Supreme Court. My lord, Supreme Court, my lord, remitted the matter to the LPA bench to decide it. My lords, in accordance with law, that order is at page 23, at page 114. That would be relevant for my lord's consideration. The division bench of the Honorable Patna High Court did not interfere in appeal against the order of the learned single judge. 114 of the brief, running page brief. The division bench of the Patna High Court did not interfere in appeal against the order of the.
Where are you reading?
Page annexure 23, page.
No, it starts with leave granted.
My lord, yes. B.B. Singh, who has been appearing in this case for the respondent, including State of Bihar and the corporation, state that there is no necessity for issuing any further notice to the unserved respondent in view of the order that is going to be passed in this case. The division bench of the Patna High Court did not interfere in appeal against the order of the learned single judge, basically on the ground that the court is overburdened with large number of cases and entertainment of such appeal would result in more flooding of cases. That can hardly be a ground for not exercising the jurisdiction. And in that view of the matter, we set aside the impugned judgment of the division bench of the Patna High Court and remit the letters patent appeal number 1078 of 2000.
All right, now where is the LPA order?
My lord, that is on the next page, annexure 24, my lord, and relevant portion would be at page 117, my lords.
Why you people can't file a certified copy? It's not readable.
Lord, operative course, if I may give a certified copy. In our view, there is no application of mind, my lords, that is relevant. In our view, there is no application of mind of the disciplinary authority while passing the order of dismissal. In that view of the matter, the impugned order dated 12th July 1996 is set aside and the matter is remitted to the disciplinary authority to consider the matter afresh, taking into consideration the contents of the inquiry report. In the result, the appeal is allowed in the time of the order of the learned single judge dated 4/7/2000 passed in CWJC as well as the impugned order dated 20th July 1996 are hereby set aside and matter is remitted to the managing director of corporation to pass a fresh orders in accordance with law. My lord, this was a limited remand. Instead thereof, my lord, by Extra 34, they issued a fresh so-called notice.
Where is that?
That is an extra one of the, my lord's IA. We have brought on record the second charge memo which has been issued in this case. An extra, my lord's.
Where is the challenge to 6/11/2004 order?
My lord, that is in the IA.
Huh?
6/11/2003 order, my lord.
6/11/2004.
That is 3, my lord. The order is 3.
Then your list of dates are, everything is wrong.
6/11.
It's not tallying with the documents.
Oh, sorry. That is an extra 34, my lords. By way of IA, my lord, we have challenged that.
Where is that, sir? IA means?
An extra 34, IA number 1, my lords, of 2018.
Annexure 34 is charge memo.
Yes, my lords.
Where is the list of documents, witnesses?
No, this is one of the additional ground that neither list of witnesses nor, my lords, list of document, and in the, my lords, in the inquiry, my lords, written statement of 2 witnesses were recorded. He was never presented for cross-examination. And additional charges were also incorporated, which was not in the earlier charge memo, my lords.
So where is challenge to this charge memo?
My lord, that is by way of an extra IA number 1 of 2018, my lords.
Read the prayer.
My lords, yes. To quash the charge memo dated 6/11/2003, issued under the signature of Chief Administrator, Bihar State Food and Civil Supplies Corporation, whereby the petitioner was subjected to additional article of charges in a pending departmental proceeding, which was remitted to disciplinary authority for limited purpose of passing a fresh order by taking into consideration the contents of inquiry report, and therefore introducing a fresh article of charges was impermissible and beyond the purview of order of remand passed by the.
On what date this IA was allowed?
Lord, this IA has been kept pending on the previous date which it was heard, lords.
Huh?
When it was heard, it was said that it will be taken
Now
up.
why there is a delay of so many years? 2003 order, you are challenging in 2018. I will reject IA.
Lords, then, my lord, submission would be, my lords.
Submission is what?
My lord, that it was a limited inquiry.
Take down first. We'll decide IA number 8893 of 2018. This IA, petitioner has assailed the order dated 6/11/2003. After lapse of more than one and a half decade, and it is not permissible since there is a delay and latches on the part of the petitioner insofar as questioning the order dated 6/11/2003 in the year 2018. Accordingly, IA stands rejected. What is the main matter? So one more IA is there. What is this IA 2 of 2019? Complete state of Jharkhand.
My lord, both the IA have been allowed. Sorry, my lord. I beg to. Both the IA have been allowed by.
Allowed on what date?
Lord, in 2019 probably. Allowed by in.
So you want me to make research? Is this matter after 4 weeks?